market because it's been on the market and will basically oversee labeling information, other packaging information. They literally look at the size of the font, the color, you know, what language you're communicating this in. If that's all approved, then there's no room for a state lawsuit that says you should have warned me better, you should have warned me differently, you should have told me something more. So preemption becomes a very powerful concern from the patient's point of view, from the provider's point of view, and a very powerful incentive from the manufacturer's point of view, because they are the ones that are off the hook. Now, you can see how this up-classification, which supposedly protects the patient, might be increasingly problematic for the patient because it's limiting the patient's remedies in the event that something goes wrong. Does the provider care? Yeah, the provider cares. Because a couple of things. When the manufacturer warns the provider, the manufacturer obviously is going to warn in very technical language. Of course it should. It's communicating with you, an expert, a professional. It should use very technical, detailed language. The law in most states then expects you, the provider, to convert that information and to sift that information to decide what is material information that needs to be disclosed to the patient in a way that is understandable to that patient. In most states, the manufacturer, as long as the manufacturer has made adequate disclosure to the provider, and as long as the manufacturer has complied with whatever the FDA is requiring in terms of warning and labeling, etc., the manufacturer is immune from suit, effectively immune from suit, and the only person the patient can look to for redress is the provider. In Massachusetts, where I live, I worked on a case long ago where my firm was representing the manufacturer of a birth control pill, and a woman took these birth control pills and had a stroke and sued the physician and also sued the manufacturer. The manufacturer said, and we concluded, we were their attorneys, we thought we had it all figured out. We didn't. We said, oh, can't sue the manufacturer, learned intermediary rule. The learned intermediary rule says manufacturer informs the learned intermediary, which is the physician, the dentist, whatever other learned intermediary, and that absolves the manufacturer of the duty to warn. In Massachusetts, however, Massachusetts usually is the minority rule. In law school, you always had the majority rule, and then there was the minority rule, and that was always wacky Massachusetts. The Massachusetts Supreme Judicial Court, the highest court in the state, said, oh, no, no, no. The information in the packaging insert that was actually in the box that went to the patient had to be not only expressed in a sufficiently technical fashion for the provider, but in a sufficiently non-technical fashion for the patient. So the manufacturer was exposed to liability. And all of the information was there, it just was not in layman's terms. So the woman said, you should have said stroke. And the manufacturer said, but I said, you know, yada, yada, yada. And she said, yeah, but, you know, for me, you needed to say stroke. And the court agreed. Well, the problem with a lot of this up-classification effort is that it protects the manufacturer and it leaves the provider standing. You may have a situation where a person is hurt and is ill and needs money just to get through life, or believes in the tort system that you should compensate loss, and that the compensation also serves as an incentive for better practice in the future. By taking the manufacturers out of the picture, you leave fewer defendants or potential defendants standing. So in the old days, there may have been a situation where perhaps the patient would have left you alone and would have gone after the manufacturer. That's difficult. That's less likely to occur if claims against the manufacturer are being preempted because of this classification system. Well, but I said personal injury suits are hard to bring, hard to win, although they are inevitably miserable for the provider. There are other efforts to protect patients and also to protect providers. States have undertaken various initiatives to protect this dialogue between the provider and the patient, to prevent the scenario that occurred in Connecticut, which originally piqued my interest in this subject, where a dentist could be punished for discussing certain information with his patient. And so many states are now looking at, and some states have actually enacted, statutes that say the risk of mercury, the question marks surrounding mercury must be discussed with the patient as a matter of informed consent. So you have this statutory dictate of what informed consent entails. And in Maine, for example, there must, if a dentist practices and uses mercury in her practice, there must be a poster displayed in the waiting room or in the treatment room. There must be a brochure that is handed over to the patient, and the Department of Public Health has a heavy hand in drafting what that brochure and what that pamphlets say. Either the dentist can use the state's brochures and materials, or can try to supplement and have that run by the state. And a couple of states are doing that. Many of those states specifically protect dentists from any kind of discipline or punishment arising out of their discussion of risks with the patient. From my point of view, just in terms of informed consent, whether I agree or disagree in whether mercury is a real problem, that's irrelevant. What matters to me as an attorney and as a patient is that this dialogue between patient and provider be protected, so that the patient has a shot at making an informed, autonomous decision. Because the law says if you're going to bear the risks, you should be the one who's deciding whether to take those on. Well, this whole preemption effect of upclassification might displace that kind of law. Upclassification might also displace the kind of law that's enacted in Rhode Island, which says that there should be greater insurance coverage for composite or non-amalgam fillings, that patients need to have meaningful choices, and part of meaningful choice is meaningful access, which is meaningful insurance coverage for fillings that are not mercury. Other states are passing or considering passing laws that ban the use of mercury, at least in some subgroups. Pregnant women, young children, patients with kidney problems are the three subgroups that are most frequently examined. Those laws are all vulnerable to preemption if this upclassification happens. Well, I'm thinking, okay, well, that's not bad if the FDA is taking care of the problem, because the reason you have this preemption is the FDA is in charge of safety and effectiveness determinations. It's a scientific body. It's informed by expertise of all kinds. Isn't it in the best situation to make these decisions? And as a federal agency, doesn't it make sense to nationalize a lot of this stuff so that all of the players, patients, providers, manufacturers, aren't stuck with this often inconsistent patchwork of state laws? The problem is that the FDA has been very, very reluctant to take on this issue, to really insist on communication in the packaging inserts and the labeling that it's passing off, it's okaying and letting it go out to the consumers. Some of its actions have been downright troubling. So when it was being pushed to make more warnings, more explicit warnings available about mercury, one of its counter suggestions was to warn about zinc. Now, I'm not a scientist, but what I've picked up on is that there are several metals in amalgams, and 50% or so is zinc, high percentage of silver, tin. What's that? Excuse me, mercury. Excuse me, mercury's high. I was thinking mercury. You needed to read my mind. That's how it works. So highest level of mercury. And then you go down, you know, silver, tin, copper, and something bordering on trace amounts of zinc. Plus, I take zinc. I take it with my magnesium and my calcium. And so the one thing the FDA chooses of all of those to mention in a warning is zinc. And I think, what, you know, are they trying to show that they're disingenuous? I don't understand this. Now, is the FDA comprised of, you know, brainless bureaucrats? No. You're not the one being videotaped. I will say this. I will say that people tend to buy into their mindsets. And so at the day I sat in my little MPH classroom, that was the day that I realized that I had somehow come to view this world very differently because of being trained as a lawyer. It was a very unconscious process. But suddenly I sat in a room where I viewed things as, you know, A, and everybody else was saying, no, obviously B, you're wrong, it's not A. And I realized I view things differently, and I'm not conscious of that. And I think a lot of us come to a task with our own point of view, maybe very consciously, more often than not unconsciously. We think we're aware of what we're doing, we're often not. You may say that there are a bunch of mindless bureaucrats. Okay, I'll give you that. But there are other well-meaning people somewhere along this line who have a very, very opposing view than the one that's being, that's been discussed in many of the presentations in this conference, which is that mercury is a very, very real problem, and there needs to be more awareness about it. That's one problem. The other problem is that agencies and licensing boards, as a lawyer, I always worry about industry capture. I always worry that the industry stakeholders are going to wield so much influence and clout, maybe because they want a regulation to go a certain way, because it affects their profit margin. Maybe they want it to go away because they truly believe in the righteousness and goodness of their product. Maybe they want it just because it doesn't really matter anyway, so let's just do what's easiest for me. But there's a heavy, heavy dominance of a particular point of view about mercury, both at the state licensing board and at the FDA. And that is very, very worrisome to me. I was having dinner with a friend of mine from law school the other night, and I mentioned I was, coming to this conference, and she said, oh, I just had a case. I just had a case. I represented a holistic dentist, and he was getting nailed by her word, not mine, nailed by the Board of Registration, which is the licensing authority for dentistry in Massachusetts, for practicing various energetic techniques in holistic dentistry, as well as chelation techniques. The Board of Registration not only took this guy up on charges, but actually went out and solicited patients to file complaints against this person. So this person I couldn't believe it. She got her client's permission to let me look at some documents, and I was really so appreciative that he allowed me to do that, and so stunned when I saw it, because it was another of the, these endless, no, it can't be moments that I've had in thinking about and working through this mercury issue. I'm reading these statements. This guy had practiced dentistry without a complaint, without one lawsuit for 25 years. And then suddenly, within a 2-year period, there are 15 patient complaints. And they're all complaining about the same thing. And then so this, out of the blue, this gentleman gets an order to show cause as to why you should not lose your license. And he's like, huh? And they said, well, you're practicing holistic dentistry, and you cannot do that under our state law. We don't happen to have a state law that says you can't do holistic dentistry, but we have a thing that says you must practice the standard of care. We don't really have anything that says what that standard of care might be, but we're not happy with you. So don't be doing that, and we're pulling your license. So this guy has to get an attorney. This is not fun. He's on the verge of losing his license. He's on the verge of losing his livelihood. And it turns out that what he had to do to resist these charges, there were hearings going on behind closed doors. He was not privy to these hearings. This is an absolute violation of due process requirements, which requires you to have notification and an opportunity to rebut any charges that are being brought to you. This is like the basis of our legal system, as foundational as informed consent. And he had to get an attorney and sue the state licensing board. So that's when my friend Ann comes into the rescue, and she sues the board. It was the only way she could get information from the board. It turns out that a member of the board had worked in generating these patient complaints, had worked in devising the initial complaint, conducting the initial investigation, then offered himself as a technical advisor in his non-board capacity to the prosecutor of these charges, and also offered himself as a technical advisor in his non-board capacity. I guess he is just a different person when he takes that hat off and puts on his other hat. He was acting as a technical advisor to the administrative hearing officer. So he's engineering this thing from start to finish. What happened was, because the dentist sued the board, and he tried to get a preliminary injunction, that didn't work. But the lawsuit was alive and kicking, and so the attorneys for him started to notice the depositions, take the depositions of all of the board members as to how they conduct business. How do they generate these complaints? Where did they generate this standard of care from? So one minute you're a board member, and the next minute you're a technical advisor, and you don't think that's a conflict of interest? And you're generating information and evidence against this gentleman behind closed doors, and he doesn't have an opportunity to confront witnesses or hire his own experts or get his own evidence to rebut this case, and you're just going to yank his license? And so he sued them for several $1 million as well as injunctive relief. And once he started taking discovery, the board decided that, maybe holistic dentistry wasn't so bad after all. So, and what disturbed me is I'm reading some of these things, and I'm always going to, these, people who are into energy healings and, the medical intuitive. So I'm kind of out there, but I'm reading these things and I'm thinking, okay, some of this stuff sounds a little wacky. But who am I to decide? He's the professional, and then, he's basically doing chelation therapy too, and I'm thinking that's not so unconventional. And so I worry about the FDA, I worry about the state regulatory boards, because at least it seems that they are very, very dominated by a particular point of view that is not only insisting upon the righteousness of their ways, but they are censoring any discussion about risks. If a patient cannot discuss these risks with her dentist, where is the patient supposed to go? That to me, I don't understand. If I went to my child's dentist that one day when he was recommending fillings, and I said, and I had the knowledge to say, gee, might there be mercury? I thought silver. I'm a literal person. I thought it was silver. And had I asked him about mercury, he would have been okay with his license had he discussed it, but he couldn't raise it with me. Especially, maybe I'm the Julie Andrews of mercury fillings. My dentist knows I'm neurotic. that I am, very obsessed over certain risks because I've had all of these horrible lawsuits that I've worked on, and I see these risks and I see these injuries, and my life experience has taught me the hard way that if bad things are going to happen, they will be happening to me. He should have, and he knew me well enough that he should have known, oh, we do want to discuss this with Mary Ann, even though I'm not going there with most of my patients. And yet, I'll have to go back to him and discuss this. I'm not sure whether he didn't discuss it because he didn't think of it, or whether, he really would take on real risks with his own licensing status had he done that. I think that's wrong. I have no confidence in that situation. Now, I will say that perhaps we can put pressure on the FDA to distance itself from the American Dental Association. Perhaps that's already happening, or at least to open itself up to a more varied array of points of view. That's a wonderful thing, but I remain disheartened because I look at what's happening in the FDA's drug safety track, and that is, that's just a lifetime movie on industry influence in FDA decision making. You can read some very interesting stories about how industry was manipulating the use and marketing of Neurontin, of oxytocin, not oxytocin, OxyContin, and some troubling things about Vioxx and other drugs, troubling stories about why is Celebrex still on the market when Vioxx and Bextra are off. And because of the publicity on that end, the Institute of Medicine recently came out with recommendations for what the FDA should do in its drug safety approval process, which is highly analogous to its medical device approval process. And what it came out with was, this is a huge bureaucracy that is highly inefficient, highly fragmented, highly under-resourced, highly influenced by industry stakeholders. It's a mess. How do we fix it? Well, you have to pour money into it. Well, currently, 1/3 of the FDA's budget, of the overall budget, not just the drug safety device track, 1/3 of the budget comes from user fees of manufacturers who are seeking FDA approval of drugs and devices. And they need more money. They're thinking of raising the user fees from $300 billion to $400 billion. That, to me, does not sound like a way to make the FDA more or less receptive to industry pressure. To the extent that more resources are needed or things have to be done differently, some of that's by virtue of the way the laws and the regs are written, are literally require an act of Congress. It's not easy to do. So I know my time's running out. I will leave you with this. It's very easy to see lawyers as the champions of patients and the major pain in the butts of providers. Sometimes the lawyers are worried about you too. There have been lawsuits where dentists and their assistants have sued for mercury exposure. That one area that deserves more study is what is the actual mercury load on persons who actually work with this material every day. If you're in that situation, this upclassification syndrome and the increasing preemption of state law remedies, whether it's a personal injury suit, a breach of contract suit, a breach of warranty suit, or a breach of a state law that is enacted explicitly to control mercury risks, all of that can hurt the provider as well as the patient. And I would say that to the extent you can, please be cognizant of the fact that the person who takes the risks should really have the ultimate say in whether to bear that risk. And in terms of a patient deciding whether to have an amalgam, we can talk about what constitutes over-warning, too much information that dilutes or confuses the message. We can talk about that. To me, that would be a happy dilemma, to be having that discussion instead of this one, which is what is happening at the FDA level and at the state licensing level that absolutely prevents this information from being disclosed to patients. It still makes no sense. I've been looking at it for several years now. It makes absolutely no sense to me. So thank you so much.